Hello, my name's Dan Dodds. I'm the principal attorney at the Dodds Law Firm in Surprise, Arizona. Today I want the purpose of this video to be that help you understand property you can and cannot pass on to others upon your death via your will. So let's jump into this. 1. I can transfer any real or personal property that is solely in my name, unless that property has another person who has a right of survivorship on that property upon my death, or I have a transfer on death deed provision. In other words, a bank account might be in Dan Dodds' name, but if I have it set up as a TDOD, that means that maybe I got my son and his name's on it. So when I pass, all he has to do is walk in with my death certificate, hand it to the banker, and 100% of that money is transferred to him. Bank and investment accounts that are contingent, they're in my name, but they're contingent to the same two, right of survivorship or transfer on death. I can't transfer something that I don't own solely. 50% interest in all the community property that I might own. But I've got a spouse. I live in a community property state. That means 50% of everything that I own that was purchased since the marriage began is community property. She already owns 50% of it. So I could transfer my 50% to somebody, but I can't transfer something that I don't have complete control over. Your interest in all vehicles, trailers, boats, timeshares, contingent and subject to the same exceptions I've already discussed. Tangible personal property of any kind, my art collection, my weapons, my fishing gear, my favorite hat. Again, I can transfer it as long as it's not contingent to someone else holding a right of survivorship, or I've set up a transfer on death deed for it. Money that I've lent to others, or someone may owe me, but I have not yet received it on the date I died. I can transfer my right to receive that money to someone else as long as it's not contingent to some clause that we've already discussed. So simply think about it this way. You can transfer anything that you own that isn't subject to a right of survivorship or subject to a valid transfer on death deed to anybody you want. So I hope that clears it up. Just remember, if you don't own it, you can't transfer it. You got to own it all, or you can only transfer the portion you actually do own. Hope that information is helpful to you. If you have any additional questions, feel free to follow up on the information that will follow this video, and I'll be more than glad to sit down and talk with you about how you can use a will to transfer ownership of property. Hope you're having a good day.